Good afternoon. My name is Ala McCoy. I'm Director of Startup Support at the University of Maryland UM Ventures. I would like to extend a warm welcome to all of you who joined us today for the next installment in Startup Fundamentals workshop series, both live webinar audience and those watching a recorded version on our Startup UMD YouTube channel. This workshop series is offered by UM Ventures, apologies, MTech at the Clark School of Engineering and Dingman Lamone Center for Entrepreneurship at the Smith School of Business. To everyone attending the live session, please feel free to submit questions using the Q&A function. You should be able to find it at the bottom of your screen. We are recording this presentation. It will be posted on our YouTube channel. So if you would like to remain anonymous, you can submit your question anonymously. As again, today I am pleased to welcome Jordan Chislom and Eli Wolfe, attorneys with Cozen O'Connor. Jordan focuses his practice on business and corporate matters. His practice spans mergers and acquisitions, emerging businesses and venture capital, entity formation, financings, joint ventures, and general corporate matters. Eli's practice focuses primarily on mergers and acquisitions and emerging businesses, venture capital transactions, from formation through exit. He also advises public and private companies in a wide variety of industries and various corporate matters. So today's webinar will discuss an often overlooked topic: what type of contracts would any startup need? We often focus on what type of product are we going to sell, who are we going to sell to, but once you made the sale and your client comes and says, yes, I want to buy it, what next? So today we will talk about what types of sales and many other contracts any business needs. So thank you so much, Eli and Jordan. I'm going to turn off my mic and camera. I'm going to be here in the back monitoring the Q&A, and please do populate those questions. Send them in. Thank you. The mic is yours.
Great. Thanks, Ala. Jordan, you want to turn to the first slide?
There we go.
Oh, there you go.
Okay. So I'll give us a quick kind of overview of who we are. First of all, we thank everybody for being with us today. This is a great, we think, follow-up to the session that we gave on Tuesday about startup equity. But we thought about this as kind of a two-piece in order to really understand the early stages of operating. It's useful to understand contracts as well. So we, Cozen, are a firm that's got about 925 lawyers, 32 offices across 31 cities. So we are pretty much everywhere in the United States. As Ala was saying, Eli and I, we primarily focus on corporate law and early stage companies, but we've got cross-functional and cross-practice groups, which gives us good insight on the problems that many of you as early stage founders would face in the future. So we're here because, pretty much any kind of legal problem that you might have, we've seen it before, and our hope is to help you understand some of our experiences and how to orient yourself as you scale in these early days. Okay, so I'll kind of give you an overview of the firm. This is just where we are in the United States. Again, pretty much every market. So enough about us. Let's get down to the substance of what we came here to talk about. So we're going to focus on these 5 types of agreements in this session. And just before I hand it over to Eli to really dig into the substance, these don't encompass every contract that an early stage company could have to consider signing, negotiating, etc. But this is going to cover a good chunk of them, right? So in terms of formation documents, what we're really talking about is the intra-company and publicly filed documents that set the governance limitations. You're talking about your certificates of incorporation, your certificates of organization, your operating agreements among the owners, founder agreements, if it's an agreement among the founders, stuff that governs internal operations of the company. And a lot of this also deals with financing, and again, we touched on most of that earlier in this week. Proprietary information and invention assignment agreements, those are the internal agreements about ownership of intangible property, confidentiality. Those things will be usually early on when a person is going to provide services to the company, founders, service providers, consultants included. So we want to make sure that we understand who owns the company's IP, and these types of agreements will set the standard there. Again, confidentiality agreements, when we really are talking about here, are not internal, but third party confidentiality and non-disclosure agreements. Those are the types of agreements that you'll often run into when you're negotiating pilots and early, kind of product agreements with potential customers, suppliers, et cetera. Commercial contracts, that's pretty much everything else. After you've locked down everything internally, the commercial agreements are going to be those agreements you sign with third parties, not for confidential information exchange, but services and your product. So we want to give you some kind of broad strokes that you can understand for how to approach those agreements. And then, of course, we'll end with equity incentive plans, which is the actual terms of how you provide equity to your early service providers, employees, and consultants included. So it's a mouthful, but that's what we're going to focus on. I'm going to turn it over to Eli, who's going to start us off with first a discussion about entities.
Great. Thanks, Jordan. Really appreciate it. And I would be remiss if I didn't include our sort of legal qualifier, that sort of this presentation does not constitute legal advice. It's purely informational. We do not have an attorney-client relationship until Cozen or Jordan or myself individually has been engaged. The views expressed here are our own and not necessarily reflective of Cozen. That being said, we appreciate, any and all questions you guys might have, and we'll do our best to provide some solid informational responses to them. For those of you who joined us on Monday, we went over this slide, so I'm going to do it at a higher level than we did on Monday. But the thing we want to have you thinking about here is, given the type of legal entity that your startup is, who is the party to the contract, right? We're talking anytime we have a contract, and mostly we'll be talking about bilateral contracts, contracts between two parties. And we might have contracts that are between, multiple parties, but we're mostly going to focus on bilateral contracts. And depending on the type of entity you are, will dictate who at the end of the day is responsible for the obligations and liabilities under that contract. So, for example, if you were a sole proprietorship, a business that's simply operated, by the owner of the business, does not have a distinct legal entity that shelters liability from the individual owner, that owner holding itself out as the business will be the party to that contract and, would be liable for all of the obligations and liabilities thereunder. Similarly, with a general partnership, each of the partners is going to take on the liability of the partnership. So while that general partnership might be the name in fact signing that agreement, those partners would have liability in respect proportionally to their ownership. Once you get into corporations, limited partnerships, and limited liability companies, which I think most of you will be those types of entities if you are not already, those are the vehicles through which you can start to shield yourselves individually or as owners from the direct liabilities and obligations under those agreements. So, for example, with a corporation, that corporate entity, let's make up a name, ABC Corp, is the party to that contract. If there are obligations owed under the agreement, if there are liabilities incurred under the agreement, the corporation is the one ultimately liable for that. That liability does not pass through to the shareholders, right? The equity owners of that entity. And so you'll see many startups formed as corporations and limited liability companies, in some cases, limited partnerships, although we see that a little bit less, for the primary reason of trying to shield its equity holders from liability. And in most cases, that liability is contractual, arising from the types of agreements we're going to be discussing today. Jordan, if you can flip to the next one. So here we just continued on. We also have limited partnerships and limited liability companies. I think we can go ahead and skip this. If you have any questions, again, feel free to drop them in the Q&A box or in the chat on this slide. But we just reintroduced this one from Monday more for informational purposes. So you can always look at that after the presentation. Next one. So now we're going to start to talk about probably the most important documents for an early stage startup. The formation documents, or as you may hear very broadly termed, founder agreements. These are the documents that establish the rights, responsibilities, ownership, and liability among the founders, the initial equity holders. You will also hear the term organizational documents, governing documents, constituting documents. These are the documents by which you form the legal entity. So you'll see that column formation. And then also the documents through which you determine the governance structure and the equity terms of your entity. So taking corporations, for example, you would file articles or a certificate of incorporation in a given state. Very often it's Delaware, but that's not universally the case. It can be in your state of residence, or the state in which the business is located. And that formally creates the distinct legal entity from its founders, from the individual owners. Now you have that legal entity. You can revert to statutory law, right, to help understand how the entity is governed. But what more often than not happens is the founders want to determine amongst themselves, how are we going to run this legal entity? How is it going to operate? What rights do we each have with respect to the entity and with respect to our ownership? So for a corporation, you're going to have bylaws that determine the internal governance. And typically, but not always is the case, you may also have a shareholders agreement that dives a little bit deeper. And this is going to talk about things such as how transferable are our equity holdings? Who has the right to appoint members to the board of directors? Things of that nature. In the other column, you'll see that there could be other organizational documents. Typically, you'll have an organizational consent when you first form to appoint the board of directors and officers, and also to outline the initial equity holding. But this is a great slide that you can refer back to if you're not yet at the stage of forming a distinct legal entity. When you do get to that point, what are some of the major documents I need to have in place so I can check those boxes? This is not the entire universe. I want to make that very clear. There could be other documents depending on the type of entity and just your arrangement with your co-founders, but these are the basic, sort of the keystone documents that you'll want to have in place when forming your entity and governing kind of the initial ownership structure.
So before we move on, we got two questions. I want to they're pretty quick. One was, where does an LLC fit into this chart? I presume that question was really about the entity chart. And again, it was covered at the bottom. It's for purposes of contracts, as Eli was saying, limited liability. So the owners, the members, are not responsible for the obligations of the limited liability company or the LLC. And the other question was, can you move from one company to another as the company grows? Sorry. And the answer is yes. The entities can change forms into another entity that's in that chart. You can convert is usually the parlance, from a limited liability company to a corporation. A lot of our clients, because it's a little bit easier to form an LLC, would start as limited liability companies, but most of the time before you start considering venture financing, you'll see them convert into corporations that are also taxed as C corporations. So the answer is yes. And it's a process. You have to obviously consider the specific state law that governs the conversion process, but in most cases, there's no impediment to it.
Yeah, and that is a great question. Jordan hit the nail on the head. We typically see startups forming as LLCs for the ease of formation, and the fact that other than filing a certificate of formation or articles of formation, you could typically have just a very short form operating agreement. In a lot of states, an operating agreement isn't even necessarily a legal requirement. So in order to create a legal entity and have that limitation on liability for your founders, often folks go the limited liability company route. And then again, to Jordan's point, as you're seeking third-party financing for a number of reasons, many of which are tax-driven, they will want to see you convert over to a C corporation. Now, because venture transactions have grown exponentially over the past 5, 10, 15, 20 years. Many states have followed Delaware's lead in making conversion a much easier process than it used to be. Historically, you actually, in fact, typically would have to create a new entity and merge the old entity into the new one. And that created a lot of its own challenges, right? As we will discuss later in the presentation with respect to contracts, you can have issues within your contracts on your ability to change entity type or to assign the contract from one entity to another. What these new conversion statutes have allowed to happen is to basically say, we are the same legal entity. Nothing has changed but our, corporate distinction, our legal distinction within that state. And so that avoids a lot of the issues that companies, previously faced when they were trying to change entity type.
Okay. All right. So I'm going to talk about that second category of contracts, the proprietary information and inventions assignment agreements. You'll see people use different acronyms. Sometimes it's called this PIIAA. Sometimes it's called a confidentiality and invention assignment agreement. Just think, when you see alphabet soup, we're probably talking about this. So, but the first thing to understand is when intellectual property is automatically owned by the company and when it is not, right? And so the basic starting place is when you create something intangible, like a drawing, for example, or you write some code, right? Or you design an invention. At the outset, that it belongs to you, the creator of it, right? And if a company pays you to do it, but you're not an employee, that remains your property, right? Well, it's not necessarily efficient to have employees always retaining ownership in property that they create for the benefit of their employers. And so the legal doctrine that kind of gets around this default is called the work for hire doctrine. And it basically says when somebody makes an item of property for hire, and the default here is usually an employer-employee relationship, the both the employer, the employer is the one that actually owns that property, right? There's a test to it. It's usually when it's for an employer, or when it's created as an express desire, an express request for and a written agreement between the service provider, which doesn't have to be an employee, and the person that hired them, right? So why does this matter for you all? The default is when you've got employees and they're doing things within the scope of their employment for your company. Well, that work is a work made for hire, right? And you as the company is going to assume ownership of that. Now, initially, with early employees, we usually advise that we go the extra step of having a proprietary information and invention assignment agreement, right? And what that does is it kind of codifies a written agreement between the employee and the employer, or the founder and the company, as to who owns the things that the employee or the founder creates in the context of the company. And it also indicates that if you're not an employee, or if we create something that's not subject to this work for hire doctrine, well, it's the company's anyway. And what you are doing in adopting this agreement is you are saying, I, as the creator of this, am assigning right now anything that I have created that for the benefit of the company to the company. And anything that I create in the future is automatically, within the scope of my performance of these services, is company property. Okay. That concept of I am assigning right now is called the present assignment. We review a lot of kind of confidentiality and consulting agreements, and this language is often missing from these agreements. Well, was the assignment made already, or is it made in the future? We want to avoid that in an early stage scenario. We'd like to see agreements that have that. Am I frozen, guys?
You're good now.
Okay, all right, great. Yeah, so I was saying we'd like to see agreements that have that present assignment of company IP to the company.
Yeah, Jordan, and just chiming in real quick, two things to think about in particular in in an early startup situation. We just talked about entity formation. What is very often the case, and especially with, technology and life science related startups, is that the IP has been developed or is in the process of being developed before we've even created a legal entity. So there is no legal entity to even own it off the bat, right? So what we what we typically do in our practice, and we look for this when we're on the investment side, is to ensure that the founders who helped develop this intellectual property at the time the legal entity was formed made a valid present assignment of all of that IP into the company, right? So that's first and foremost. And what very typically happens is folks say, oh, well, my intent all along was that this was going to be owned by the company, right? Because I was developing it for this new business and then I formed the entity. But your intent isn't good enough in the legal eyes, right? And especially when it comes to the U.S. Patent and Trademark Office. The second aspect with respect to early stage companies that's important to be mindful of is many of you won't have employees to start, right? And maybe won't have employees for some time. Now, even though you might think of certain individuals as employees, they may not be, right? You may have a very explicit contractor or consulting relationship with those folks. And so that's why it's extra important in those initial written agreements to have this work for hire language as well as present assignment of IP language. And Jordan and I could tell you a million war stories about how we have reviewed documents. We've even gotten to the stage of the company getting ready to raise millions of dollars. And as it turns out, the critical intellectual property of the company, the reason the investor is putting money in to help it scale up, there's a question around whether the company has 100%, unencumbered ownership of that intellectual property. And that is an issue you do not want to face when somebody's getting ready to send you a wire or cut you a check for millions of dollars, right? So
Right.
we always advise folks it is worth the money and the time to make sure you have all of this stuff in place at the outset. Can it be cleaned up later? Sure, but you will spend more time and more money doing so after the fact. And again, we understand that startups are typically, don't necessarily have the financial or even time resources. And they say, you know what? I don't have the money to spend on legal to do this right off the bat. Spending that extra time and money at the outset will save you well more time and money down the road in getting this stuff right, and particularly in this area.
And there's two sides just to kind of if kind of a war story on this. You know, many people will just go online and pull forms for this, right? And we try, I say try, almost straining to do so, to advise our clients not to just pull forms because there's nuances, right? We talked about the idea of a present assignment. Well, what are you assigning, right? In some cases, maybe you have a serial or a consummate founder who's working on multiple projects where you don't want to give everything that you own to the company. You want to give whatever was related to this specific project that you've been working on, right? So the flip side of having a really strong form is that you may encounter a co-founder who, is working on multiple things and you don't want to necessarily put all of their IP that they have into the company. You only want to put that slice that matters for the company. So that language can be nuanced and it makes sense to sit down with counsel and talk to them about it and make sure that you're not taking more than you need to take or not taking enough of the company's IP. All right. So so what we just talked about with PIAAs is internal confidentiality and internal ownership of IP. But I think we've all seen non-disclosure agreements before. I think it's one of the things that's probably abused more so than in the past, or people will just pull an NDA and present it to another party. And so we're talking about this because this is the stage in which the company is going to start sharing its ideas with other parties. Let's assume you've got all your internal IP locked up, you've got confidentiality agreements among your founders and your early service providers. Well, now you got to start going out and talking about your business and your product to the world, but you don't want to do so in a way that basically opens up the hood and reveals everything for anybody who's interested to see. And so the confidentiality agreement, or the NDA, is a way that you can agree for a limited purpose to exchange confidential information with somebody for whatever purpose you want. And typically, a purpose is to explore a business transaction. Another purpose could be to develop a service for your company. If you're going to hire maybe a web developer, and before they can really give you a quote, they need to know exactly what type of business and data they're dealing with, right? So the purpose of the exchange of this confidential information is going to be covered by an NDA. And a good confidentiality, or NDA, has a very detailed description of exactly what constitutes confidential information. A couple of the examples we have here: business information, trade secrets. Those are things that are kind of obvious. We usually think of those as the secret sauce, but other things we would consider secret sauce too. Pricing information. You may have a competitive advantage over your competitors if you can just offer services at lower prices, but you don't want the world to know what your pricing is, right? Personally identifiable information about the parties to the contract or the individuals behind it, right? If you're going to give somebody a huge data set, it could have a huge wealth of information that, if they weren't subject to confidentiality, they may feel compelled to just sell, right? And so you want to discourage doing that. But the whole point of this agreement is the parties to it are agreeing to receive confidential information and not disclose it. And so any number of people could be parties to an NDA: an employer-employee, two contractors, a consultant, people who are acting as joint venturers before they actually formally negotiate a joint venture agreement. Seller and buyer in a merger and acquisition transaction, is really no limit to how you could use them. I think that the final thing to understand is that there could be a lot baked into a non-disclosure agreement. It's not usually just, I agree to hold this confidential. There's many times exceptions. Well, what if I am compelled to disclose because I got a subpoena? Well, a well-drafted NDA will cover that. What if somebody else finds out about confidential information and it wasn't my fault? Again, a well-drafted NDA will cover that. In many cases, particularly where we're talking about a company providing a service, which is going to be many of you as founders, you'll want to make sure that the person that you are pitching your service to doesn't turn around and hire your entire staff, right? So you'll often see non-solicitation clauses, non-solicitation of employees and consultants, and sometimes even customers, right? So we often look for these types of things in an NDA, and it also matters the direction in which the information is flowing. If one party is disclosing, the other is receiving, that would be considered a unilateral NDA, where the disclosing party doesn't have any obligations because they're not the one that's receiving anything. A bilateral or mutual NDA is one in which both parties are exchanging information back and forth, and therefore they both have that obligation to keep the other party's confidential information confidential. And so it's one of the things that we look for when we advise clients is, well, who has this obligation and what exactly is it? The last thing you want to do is, if you're giving critical information, to have a well-drafted NDA that says, oh, and you only need to do this for 1 month or 6 months. It doesn't really protect you. It kind of, you're creating an opportunity for the other party to be waiting for the clock to run out, and then free to go out and use that information you gave them however they please.
Yeah, one other thing, Jordan, I wanted to add on this is, it's similarly with the IP assignment documents. It's critical to get this right the first time, but once you do, you can really have a very, very good form that then you can pretty much use without legal counsel. Now, if you get one from a third party, you're certainly going to want to have your counsel review it. But my practice with the startups that I represent is to very early on develop them both forms: a unilateral non-disclosure confidentiality agreement and a form of mutual confidentiality agreement that is thorough and robust and allows them to not have to come back to me every time they want to have a conversation with somebody or share some information. They can really just plug in the counterparty name, date it, and sign it. But I know that I have developed a really, really good form for them that is, to Jordan's point, going to withstand the scrutiny of another counsel on the other side, investors counsel, and I can feel confident that my client can go out and use this form without edits and without the need to come back to me. But again, we all too often the quote unquote war stories come up when somebody just Googles for a form, pulls it offline, assumes that it came from a reputable site, a reputable law firm, what have you, and just goes ahead and starts using it without thinking through all of the things that Jordan just talked about, right? Duration of the agreement, scope, who's covered, the information that's covered, what are the exceptions, non-solicit, etc. So having a really good form of confidentiality agreement is well worth the time and effort up front that you will save versus potential litigation down the road because somebody is all of a sudden using your know-how that was not properly protected by one of these agreements. All right, so commercial contracts. This is the broadest category we're going to talk about, and we've kind of sequenced our discussion today in order of, internal foundational documents to, internal informational protection, intellectual property protection documents, to now we're venturing out, right? In the NDAs and confidentiality agreements, we're starting to contract with third parties outside of the company. Now we're taking this another step further, right? Those NDAs might now turn into a situation where you and the other party to the non-disclosure agreement or the confidentiality agreement have looked at each other's businesses and say, okay, we want to enter into a formal contract for services, for products, and what is that next step? So, at a very high level, we can talk about services contracts, as you will see in the first bucket, whether, those are employment contracts, contracts with independent contractors, contracts with board advisors, anybody who might be providing a service to the company. That could even be web developers, anybody else who is going to help the company kind of with their business. You also, I think it's the third bullet point, have contracts for tangible goods, right? Is there a good that the company is providing to a third party or a contract where the company is contracting for those goods? What is key, I think, here is that second bullet point. And again, this is another area where we see where we probably have a few war stories, but typically you'll have one-off contracts, right? A very discrete, I am paying you X number of dollars for Y number of your goods. You have given me the goods, I have paid you the money, the contract is over. Versus a longer term relationship. Typically, we see that a little bit more with services, right? A multi-year contract where I'm going to be providing the services to you over a longer period of time. But we can also see that in contracts for tangible goods, right? You are going to be the provider of this good to my company for a number of years. Now, each of these has its advantages and its disadvantages, and I think it's critical as an early stage company to take a close look at this, right? Because what often happens, and we can give examples of both situations, you can have a one-off contract that's a great arrangement for your startup, but it's just that, it's only a one-off contract. And so you've gotten the goods or the services and you paid for them and now it's over. You would have liked to maybe have locked in the terms of that agreement for a longer term situation. But now the counterparty sees, oh, well, your business is growing. You're able to pay more, or it's going to be harder for me to provide as many goods to you. I want to change the terms of the contract. The counter to that is in a long-term relationship, right? You may sign up a 2, 3, 5 year arrangement with somebody that at the time seems like a great business deal, a great business arrangement for you. But what happens in a year, 2 years from now, where your business has scaled up drastically, right? Now you can be much more competitive from a pricing perspective. Now, instead of paying X number of dollars per widget, because I'm buying so many more from you, I should be paying a fraction of that amount, right? but unfortunately, I'm stuck in this long-term arrangement. So getting these right early on, it's a little bit more of an art than a science, unfortunately, but that's something that's critical for early stage companies to look at, because all too often they find themselves either stuck in situations that no longer reflect the actual business need. And the counter to that is having had a great arrangement with somebody that unfortunately has now ended or terminated, and you want to do it again, but that counterparty is looking for more advantageous terms themselves. Um, the last bucket, and it kind of fits within this, but the last type of contract we're going to see with sort of, third parties or new third parties to the company are investment/financial contracts, right? Whereby you are taking in money from a third party in exchange for a promised return, right? Scaling up the business for an ultimate exit, or even just giving them a present return, whether through a preferred return or a dividend. And we're happy to answer questions on those. We hit on that a lot, I think, in the equity presentation, so I won't delve too far into that. But again, if you have any questions on commercial contracts generally or things to look for, please feel free to drop it into the chat or the Q&A.
Okay. So the last category of contracts that we're going to hit in this presentation is equity incentive plans. So this does dovetail with that equity conversation. What we're talking about is when you have people who are doing things for the company, but you're not paying them in cash, right? And this is the case for many early stage companies. You don't have any cash before you have a product, you don't have any revenue. And so the only thing that you can give is the promise of a return, or the hope of a return, I should say, for the future. And the way that we do it is by giving service providers equity. Right. All the reasons why you do it are clear, right? You want to attract people to believe in the vision, and the upside opportunity to get hopefully millions of dollars later on down the line once the companies hit it big. It's attractive to people. You're also aligning interests, right? If you're a founder of a company, you want all the people who are going to be in the trenches working with you to have the same exact interests as you. Well, what is a different type of interest, you say? Well, what if somebody is just getting paid a lot of cash, right? Every time you pay them, they're not necessarily as invested in the long term as somebody whose entire, kind of interest in the company is put off, is in the form of equity upside, right? So for a lot of early stage companies, you want the early team particularly to be incentivized by getting equity. And then of course, tax considerations. If I were to just give services to the company and get paid for it, that's income to me, and we tax on it accordingly. Well, equity incentive plans, very similar. You're getting services for a compensation, but the compensation is equity, and equity can change in value over time. So the tax consequences of giving somebody equity are something that you want to pay close attention to. And there's also rules about when and how often equity, when provided as comp or services, can be taxed, right? So the equity incentive plan is a document, a standalone document from all those other things that Eli and I were talking about earlier, that sets the rules for how for your company equity incentives will work, right? And it's one of the things that comes up in almost every financing negotiation, because every time you give incentive equity to service providers who are not paying cash for it, whoever has equity or whoever is investing equity is being diluted. It is accretive though, right? It's because the pie is going to grow when these people who have received equity do the services for the company. But we want to make sure that we have alignment with all of the founders and all of the investors and all the equity holders about exactly how that dilution is going to happen. So again, a standalone document that sets out how many shares of the cap table in the company are even subject to the equity incentive plan. It's not an unlimited number of shares, because that again leads to unlimited dilution. Exactly what form of equity incentive or what form of equity can somebody receive when they get shares out of this plan? Sometimes it's options. The idea of an option is I can, if I choose to, acquire common stock, but I have to pay an exercise price, right? That's different from restricted stock. I am getting equity, full common stock in the company, but it has some restrictions to it. Other ways that you can make equity incentives are what are called stock appreciation units, which honestly doesn't happen much in our practice, but interest in the growth value of the company, but not necessarily stock. So there's the plan will kind of set out all the different categories of equity awards that can be given out of this, in the company. And usually there's going to be not just the plan, but an award agreement. So the actual issuance document that says Jordan, or you, Eli, are receiving an equity award from the company for this many shares, and it is subject to the plan and these additional restrictions, right? So you got to think, I don't just have a plan, but I've also got to tell each recipient exactly how much they're getting. That's going to be the award agreement. And then finally, the plan will have additional provisions about, or can, if you choose to, have provisions about vesting and restrictions on when somebody actually has the right to the equity. We get this question a lot from founders, and the concern is clear. If I agree to give somebody, let's say, 5% of the company, do they have it all on day one, or does it happen over time? The way that we make it happen over time is by imposing vesting restrictions, right? By saying you won't get your whole 5% today, you'll get it after in a certain time period. Usually, you'll see a lot of equity plans provide for a 1 year cliff, and then monthly over the next 2 or 3 years, right? What that means is for the first year, you don't get anything, and if you leave the company, you actually forfeit this equity because we are aligned that you're not getting the equity until you've met this milestone. So that's the idea of a cliff. But then after you've met your cliff, usually you'll vest in a certain percentage of the equity award, and then in equal installments, usually over time. So this is just an example, but the idea of it, again, is you can structure your equity plan and your award agreements in a way that doesn't give all the equity that you hope this person will eventually own immediately. It gives it to them over time.
Yeah, and I think just piggybacking off of that, Jordan, two things to think about here. One, with respect to the vesting and sort of restrictions on whatever you are granted. Oftentimes, even when stock or options have become vested and they are not subject to forfeiture any longer, to the extent you've awarded a material amount of equity to somebody who has now left your company, maybe not on the best of terms, you don't necessarily want somebody like that on your cap table or sort of having governance or financial rights in your company as you continue to grow. And so plans very often also will provide for, even with vested awards, what happens if somebody is terminated for cause or leaves voluntarily, right? Very often gives the company the right to buy back those shares at a certain set price, whether it was the initial issuance price or a kind of generic fair market value to be determined at the time of that action. But that's something that there are times where we don't see that included, and it is critical because, you don't want necessarily proverbially a squeaky wheel on your cap table that is no longer providing anything to your company, but still owns a significant piece of equity, even still being a minority holder. And just the last comment I will make on this is what Jordan and I encounter all the time and far too often is people feel like an equity plan is a complicated document that takes time and resources to put in place. And they're very worried about just getting the company up and running, focusing on developing the product or the service or the intellectual property that forms the basis of the business. And so they say, you know what? We're just going to kick this can down the road. We'll deal with it when, we have third-party investment come in. We can't really worry about that right now. Maybe that's okay. But where this is an issue, and as Jordan sort of alluded to this, is all too often we see early stage companies engaging, whether employees or independent contractors, and giving them a very broad stroke promise. I will give you 5% of my company in exchange for the services you are going to provide. Well, as a lawyer, I then ask a bunch of questions. Well, 5% now, 5% at that later date when I'm ready to issue it to you. How are we valuing that amount? And the issue that arises is 5% today, where my company really might be worth basically nothing, right? I've just created a legal entity. We're developing some IP, but there's no real, valuable assets yet in the company. Okay, 5% is not really worth that much. But 5% a year from now, where I've filed my patent, right? Or 5% a year from now, where somebody's looking to invest 5, $10 million in my company, all of a sudden is worth quite a lot, right? And your intent may have been, oh, no, 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 I meant 5%, from when we initially signed the agreement and when we were an early stage company. But what you signed with that provider doesn't actually say that or doesn't spell that out. And now all of a sudden they have a very valid claim to say, no, you promised me 5%. And that is at the time that you're getting ready to issue me that 5%. Well, now you have this investment coming in. I want 5% of the post-investment company that's now worth millions of dollars. That's probably not what you signed up for or what you intended. Putting an equity plan and forms of award documents in place avoids that situation down the road. And I probably harped on this throughout this entire presentation because it's sort of my general message to startup founders is I know that startup founders are strapped for time, or strapped for cash, or strapped for other resources. And you have to determine where am I going to allocate the time and the expenses, right? And very often it's towards just the immediate business needs, developing the product, developing the service, developing the intellectual property. But what I can tell you is invariably putting some of that time, money, and resources into getting these legal documents right up front will pay dividends down the road. And we see it all the time in seed financings where an investor comes in and says, you didn't have an equity plan in place or you made all the promises. Now we need to clean all this up. We need to do all this extra work that could have been avoided had we just put this in place from the start. So again, as you guys are, forming your entities and thinking about these things, we urge you to engage legal counsel early on and at least have this conversation. Again, I'm not saying that every startup needs to put a full-blown equity incentive plan in place and have all these forms of award agreements. But at the very least, you need to have given some thought to it and understand why you may not do it and what the risks are of not putting it in place up front.
Yeah. It's the equity plan, just to kind of add a thought, Eli, the equity plan conversation is the perfect example of the fact, the idea that one relationship could entail many different types of contracts, right? The perfect example is I'm a consultant, I'm going to do your web development, but you don't have cash to pay me, you pay me in equity. Well, what is our relationship? I'm going to do services for you. We're going to have an independent contract. We want that independent contract to have IP assignment and confidentiality provisions so I don't take everything you give me and give it to the next company and kind of take advantage of your company. Well, if you're not going to pay me with cash, you're going to pay me with equity. Well, I'm going to need to see your equity compensation plan to figure out how many shares are in the plan and what the restrictions are, how you can take the equity away from me. And okay, you're going to put in my independent contract the fact that I'm going to get equity, but I actually need to get the equity. That's going to be in the award agreement that's going to come later on, right? We have a lot of clients who do it all right, and then at the 1 yard line, like the Seattle Seahawks, at the 1 yard line, they forget that they have to actually issue the equity to the person, right? And then the entire relationship is now in question because the person may have performed the services, but they never got the compensation, the equity, right? And so again, if we're hammering this point, but it's important. You have to kind of realize that in doing this, there's all these different relationships and angles that have to be considered. Okay, so we're going to end on this slide and hopefully leave some time for questions. I haven't seen any Q&A come in, so I'm hoping that means we didn't put you to sleep. But this cuts across all the agreements that we've discussed, right? And we could spend an hour on each of these topics. We don't want to do that, but we did want to give you a flavor for when you receive agreements or when you're preparing agreements, some of the things that you could view as important material, right? So just to give you a quick overview, and I think this is a good time to kind of stop and ask you some questions, is one term. How long is the agreement in place? If it's a long-term agreement, is it, or is it just a one shot services, goods, compensation, boom, done, right? So this is important because you want to consider, well, how long do I have to actually consider this agreement, and how long do I need to consider my performance, and is my performance ever done? So the term is how we would refer to these set of questions.
And one other aspect on that, Jordan, is not just the term, but what happens at the end. Does it automatically renew? Do I need to provide you with notice that I'm intending not to renew the agreement? Um, some contracts will be silent. Oftentimes, we find folks realizing, oh, I needed to let them know 30 days in advance that I didn't want to renew this agreement. Otherwise, it renews for a year, 3 years, 5 years. And all of a sudden now I'm locked into another 3 year term of this agreement because I noticed with 20 days left in the term that I needed to provide notice 10 days ago. So as Jordan noted, there's a lot, we're just saying term, the length of time, but there's a lot of things to think about just within that one bucket.
Right, right. So the next bucket is compensation and consideration. So we put those two words because they mean similar things, but not exactly the same. So we think of compensation as, what am I getting paid? Right? Well, you could get paid in cash. You could also get paid in property. That's equity is a form of property that could be compensation for services. But then there's the idea of, well, what if you're not going to give me something? But what if I'm going to do something for you? That's the idea of, I'm going to do something for you in exchange for you doing something for me. In contract law, we would call that consideration. And even compensation is a form of consideration, and it's like core to when contracts are enforceable. So you got to consider that as well. In many cases, if you're dealing with another early stage company, nobody has cash to give. Nobody has equity that they can spare to give to another company, but there is a reason that you want to work together. Well, what if you do things for one another? You share information, you allow the other party to use your product, and vice versa. Well, now you have an enforceable contract because there was an exchange consideration. Performance obligation, just what do I have to do under this contract, right? It seems simple, like, well, I just, pay or give services, but it's not just that, right? Maybe you've got performance standards that you have to uphold. That's an ongoing obligation. Maybe you have ways that you have to report back to the other party and to give them information. Maybe it's access. Maybe I have to open up my code base or my book and let you see it so that you can verify that the services that I'm giving you are real. You don't want to get kind of stuck in an unfavorable disclosure scenario when you really wanted to do something really narrow and specific. So just being mindful of your performance obligations is important.
And I think the key thing there, Jordan, is that just going back to like, just because you've delivered the main service or the product does not mean that those obligations are done, right? Have you warranted the quality of those goods or services such that 6 months after I'm done, it's not working the way it's supposed to? Do I have an obligation to go in and fix it, to replace it? We very often see contracts that the actual kind of meat of the contract, the good or service was done a year ago, right? But there are still ongoing obligations among the parties that can last for, multiple years after that sort of initial provision of the good or service. And so thinking ahead, how long am I, on the hook for this good or service is a really important consideration as well.
Um, so we've already got a question, so I'll just end on these 2 points. Exclusivity and restrictive covenants. Exclusivity is, I'm going to do something either for you only, or you will do something for me only, right? It's the parties almost entering into a relationship with one another for a specific thing, right? For if you've got a particularly good product, giving somebody exclusivity to your product can be, it's a huge value you're exchanging, because you're foregoing the ability to market that product to somebody else and maybe learn something more about the value of it from other parties. It's hard to get a market when you only entered into with one person. Restrictive covenants, we talked earlier about non-solicitation. That's when I'm not going to take somebody, or I'm not going to hire somebody, but there are other ones. You probably heard non-competition, right? I'm not going to even compete. I'm not going to be in the same industry. Other forms could be non-disparagement. I'm not going to disparage or talk negatively about you or this company. All those are different versions of restrictive covenants, which are different than a lot of the other provisions that we've been talking about, and that courts often scrutinize these quite closely. So a not well drafted restrictive covenant is something that could be scrutinized by a court and struck down. So again, important to work with counsel and figure out, is it reasonable? Is it exactly what you need when designing these terms? And lastly, this is a huge subject area, risk allocation. This is about when we enter into contracts with people. It's not just about what we're going to do for each other, but what if we don't do what we say we're going to do for each other? There's a lot of contractual provisions that think through this concept of, well, if I don't do what I said I was going to do, I've breached the contract. Is it a small breach or is it a big breach? If it's a big breach, do I have to keep up my end of the bargain? And if I've breached the contract, is the other party damaged? Or what types of damages could I potentially owe the other party? In what scenarios do I agree to hold them harmless? Do I agree to be on the hook for something that I haven't done or for something that we've specifically agreed? So these are all risk allocation and shifting mechanisms. These are the ones that the lawyers pay a lot of attention to because they're usually, really, really fat, right? And a lot of times you can get lost in reading them. Again, when you have a contract, thinking through, well, what if things don't go how we plan them to go is just as important as defining exactly what is planned, why you're entering into the contract.
And I think to put a bow on this, Jordan, before we get over to the question is, at the end of the day, all of these contracts we've been talking about, right? The idea of a contract between two parties in general is an exercise in allocating risk, right? So even these categories that we talked about before, the risk allocation category, the term, am I mitigating my risk by having a shorter term agreement or by having a longer term agreement? Depending on the nature of what the contract, either one could help mitigate my risk, right? I have a long-term agreement, I'm locking in a really good price. I'm mitigating the risk of, price increases, right? Absolute flip side, I have a short-term agreement. I don't know what's going to happen a year from now. I want to mitigate the risk that something's going to happen a year from now and I'm going to be locked in to a longer-term arrangement. So all of these, items to be considered in a contract, and then even within all of the different types of contracts we've talked about, right? From independent contractor agreements to invention assignment agreements, they're all allocating the risk between the two parties to that contract.
Right. So that's our talk. We did get a question, and feel free to send any others. We'll try to go through these quickly. The question is, if you're developing a consulting contract where you're providing services to a company, how do you ensure that you're not shortchanging yourself in what you're charging? Should you have standard pricing or different pricing for different types of companies? This is kind of a legal but mostly business question, right? It's how do I value what I do or what my company does, right? This is one of the we talked about compensation being a term of the contract. We as lawyers can help you think through how to think about how you charge for your product, but the actual exercise of setting a value to it is risk allocation, right? It's your product, your market, and we're going to rely on our clients in many cases to tell us what they think the value proposition is. Can you offer multi-tiered pricing or standard pricing? Absolutely, right? And a lot of that is, you don't have to put in every contract the entire panoply of options. If somebody wants one specific thing, you can just put that in the contract. You don't have an obligation necessarily to offer what you offer one customer to another customer, right? Because that's all part of the confidentiality, the secret sauce that you've built the company around, right? So it's most convenient to think of pricing in a one-shot way, but in actuality, particularly in the early days, you're going to be trying a lot of stuff. You're going to be experimenting how pricing models for one type of client works, and it may be completely different for another type of client.
And I think, Jordan, as well, this is a great example of where the interplay of these, key terms is going to come in, right? Because, if this is a short-term agreement, it's kind of one-off, and you find out after the fact that you underpriced, not necessarily a huge risk. You're signing a longer term deal and you're concerned that a year from now, I could be, based on kind of market rates, charging double what we're charging in the initial year. Do I have a term in the agreement that allows the parties to mutually agree to change the pricing or to reevaluate it? Do I even have an automatic escalator, right? You see that very often in real property leases where it just says, here's the base rent, but every year it's going to go up by a standard 3% or 5%. So again, these are primarily business considerations, but there are different legal avenues within the contract that you can use to kind of mitigate the risk that you're going to lock yourself in on a long-term basis to a price that turns out not to be sort of as high as you would want it to be. Jordan, we also did have one more in the chat. I know we're at 2:01, so we'll hit this one quickly. We have a question about common issues for folks developing apps and software. I'd go back to that slide on the confidential or proprietary information and invention assignments, and just assignments of IP in general. To the extent that your business is developing, is just purely in the business of developing intellectual property, whether that's an app, a software, what have you, it could be a patent. Those agreements are absolutely critical because all too often we see folks engaging developers, consultants who are going to help them, develop the app, develop the software, even if it's just the website, right? The forward-facing aspect of the business, not have robust intellectual property assignments within that contract and not sort of dealing with these issues. So in particular, folks in the app and software space, it is absolutely critical that you have really, really good forms of your intellectual property assignment docs, or within the consulting agreement. You may have a form consulting agreement that you're using for folks who are going to be working on your product, has to contain that language, has to be robust and very thorough. So if you're doing apps and software and you don't have a lawyer, get one engaged sooner rather than later. The worst case scenario you could find yourself in is you're developing, right, the next unicorn of an app, and you have a developer come and say, well, I actually own, 50% of that, or this was my idea and I never properly assigned it. And nothing kills value in a company more than an ownership dispute when it comes to intellectual property.
Yeah. To one additional thought to the kind of app question, maybe not necessarily what you agree to do for the customer, but what did you build it on top of, right? If you built your app on open source software, for example, right? Well, there are restrictions in open source licenses that will automatically, by you using the open source, code of the open source license, the app that you develop is now subject to those restrictions, right? If you use, university or other institutional technology to build your app or to build your service, those are all incorporated in what you can do. And you want to make sure that you're not infringing on somebody else's property rights, which if you don't think about, won't even come up in the agreement that you're negotiating with your customer, or it may come up in a way that's unfavorable to you, like you saying, I'm not infringing on anybody's IP. Well, are you? Right? So just again, working with counsel and just kind of understanding exactly what you are building and what you built it on top of is also important, particularly for app developers.
And that's in the contract with your customer. And then going back to the extent that you're having any third party helping you, that you might not, given the nature of an independent contractor relationship, you're not sitting with them side by side day to day watching what they're doing. Do you have robust representations and warranties in that independent contractor agreement that that person is not going to take third-party intellectual property and add that into the product they're developing for you, right? So having that sort of language, those reps and warranties in that agreement would allow you recourse against that developer to the extent you found out after the fact, oh, they actually included, proprietary information of another party in my product, thereby making it an infringing product. Who can I recover from? If you don't have that language in there, you're not going to have a legal claim against that individual. So it can definitely work both ways. It's not only when you're dealing with a customer, it's also with the person who's helping you create the product for the customer. I think with that, we've already taken, as we did the last time, a little bit extra of everybody's time. I don't see any other questions in the Q&A or chat.
Yes, thank you so much. Similar to last week, to Monday's session, you can take a whole week probably talking about it. It's a huge topic, but so important, and so many startups don't think about these things, and until it might be too late. So really important. Thank you so much. Again, like the previous session, I will post this on YouTube. Anybody who would like to, please feel free to go and rewatch it, or let me know if you would like to get a copy of the slides. I can share a PDF with you. So thank you so much, Eli. Thank you, Jordan. Really very appreciative of your time and your expertise today.
Great. Thanks, everybody.
Thanks,
Appreciate it.
Ala. Thanks, everyone. Bye.
Thank you. And thank you, everybody, for great questions.